and president. For today's program, we're going to talk a little bit for the next, or rather for the next hour, about the Federal Court Advisory Committee, which is a committee that serves lawyers throughout our community. So I'm very excited to hear from every single subcommittee chair, which we have in front of us, or some step-ins, to talk about the work that's being done and the work that is hoped to be done. During the break, there will be lunch available, so please help yourself to that. Speakers here will all be using their microphones so that the people in Zoom land can hear. In the event of an emergency, people should exit exactly how they entered. And for the, unless you're in Zoom, in which case, do what you have to do. If you are on Zoom and you do need CLE credits, please email Raina Smith. Her email will appear in the chat box in a moment. And so now, without further ado, the chairs of the general Federal Court Advisory Committee, I'll throw it to Mark DeSisto and Lynette Labinger.
Hi, I think I need to be taller to get over this monitor here. Can we move it down? Okay, I better posture. All right. No, I'm okay. So I'm Lynette Labinger. I'm one of the co-chairs. I'm honored to see that, in keeping with the old law school tradition, there's no one in the front row. At the last bar meeting that I was at, where I was in the way back, and Justice Long said, "Everybody move up," and I got to sit next to her. So I'm still encouraging you for the second half, move up. Particularly the second half, we're hoping to have a lively discussion, and that means you need to get closer. And welcome to everybody. It is, I mean, it seems like just yesterday that we were all scattered and isolated by the pandemic, and it's really exciting to see so many people and to find out truly how short I am. So I'm one of the co-chairs of the Court Advisory Council, which was developed at the beginning of 2023. It was a realization of a vision of Judge McConnell to replace 5 separate standalone committees that had functioned for the court into one overall group of attorneys to provide review and input on the various aspects of what those committees we're doing, and also to provide review and input into all programmatic aspects of court processes, to come up with some new ideas, to provide feedback. And as a group, we meet about every other month to discuss developments and our efforts, and also to address old and new issues. And in between, we've broken out into 5 committees. You're going to hear from all 5 committee chairs or their designees today to get more information about what they've been up to. And these committees have also broken out into sometimes into subcommittees as well. I try to attend most of them, mostly by hybrid, but I think I've been at over 30 meetings in the course of the past 8 months or so, and it's been very active. And the committees are the local rules and practice, access to justice, CLE and the district court conference, criminal law bar and probation, and a DEI committee including outreach to the community. Most of the members of the council serve on 2 committees, and they're free to attend any meetings that they want. I mean, I know from my own experience on serving on court committees in the past, such as the First Circuit Rules Committee and the Board of Bar Examiners for the District of Rhode Island, that the committees tended to work reactively when called upon by the court to address a particular issue or to comment on a rule or to conduct the old bar admission practice. And they'd work in silos, and they'd be activated for specific purposes and at limited times. In contrast, our committees are basically meeting throughout the course of the year, and this is generating new discussions, sharing ideas across the committees. So it's very interactive and dynamic, and it sparked a lot of debate. And you will be hearing more about it from the individual, about the individual activities from the committee chairs. And with that, in Eddie's words, I'm going to throw it to Mark.
Hello, everyone. I usually don't have much to say after Lynette talks. I just agree. So it's been working. So I just think about this for a minute. This is a unique council in a number of ways, and Lynette touched on this. We have the ability, and I'll tell you who the we is in a minute because it's all of us, but we have the ability to think of ways to improve the court, improve our practice, doing it on our own. We really, we take advice and recommendations from the court, but we don't need to do that. We can sit and say what needs to be fixed or what could be improved, and we can do that. And the chairs will tell you, we've done that. So what I've found in this last year is this free exchange of ideas back and forth, which is exhilarating. I mean, it really is. And we have these debates, we talk about it, people bring to the table different things, and we come up with recommendations. I just wanted to stress one thing, that when Judge McConnell and Nora advised us of this, that one of the main focuses was that this should be something that everyone in the bar should participate in, whether you're on the council or not. And we've tried to do that. I think we can improve on that. I'm going to tell you some of the ways that we've done it. We actually had an attorney want to speak to the council on a particular issue and came in and did it, but not on the council. We encourage that. Talked to a number of people, Foley and Sorelli. You know I've talked to them. Peter just agrees. John actually, but I've reached out to a bunch of people, and I encourage that. I think we should do more of that. So if you have anything, like today, if you have something, bring it up, because it will be, we'll go with it. We have sent surveys out, and they've gotten tremendous responses. One of them is on the CLE committee. They wanted to know, what is it that the bar would like in CLEs, and I'm presuming someone's going to talk about that, maybe Dan. And we get a response to that. And of course, the big issue was depositions. We sent out a survey on that, and you'll be amazed at, and I applaud all of you. The responses we got back were extremely good. So one focus here is to make this council the voice of the bar, and the way to do that is for you to keep participating and go from there. Okay, this is the shortest closing argument, and not as effective as my usual ones,
Thank you, Mark and Lynette. Now speaking for the Rules Subcommittee, the chairwoman of that committee, Donna DiDonato. If you're more comfortable, I think that, can everyone, I don't know if that mic is hot. I don't know if
It's
you want, if you're comfortable.
With my voice, I don't need a mic.
Okay, well, the Zoom does.
Oh, okay.
Sorry, yeah.
Hi, everybody. It's very odd for me to be on this side of the table as opposed to where you're sitting. And often we've been at conferences, we've been at seminars, we've been at CLEs to be enriched by speakers in their area of specialty. So that could only enhance what you already know on that particular topic or on that subject. The way that I look at the CAC, the Court Advisory Council, is that we want to be interactive with you. You practice, your practitioners, your litigators, just like we are. And we want to help facilitate that experience in court. if you're in a particular case or you're doing research, you're trying to do what is best for your clients within the confines of what the rules allow. If there is some reading of the rule or a segment of the rule that seems to hold you back as opposed to be assistive to you, that's the type of feedback that we want on the local rules committee. We want to know what we can do to review the rules, perhaps revise them, and make them more productive for your practice. I want the rules to be very practical, very day-to-day. They're not doing any good sitting, and on some site that you look at or the old-fashioned way of looking in a book if they're not assistive in your practice, whether it's on a motion practice, whether it's at a hearing, whether it's on the civil side, whether it's on the criminal side, whether it's on trial. You need to use those rules for your benefit, and if you feel as though something is not working properly, contact any one of us. I am the chair, but I've also been really blessed with the fact of who is also on my committee. And I'm going to give you each of their names. You can reach out to me or to them directly in any manner that you want to present a topic for us to research and discuss and make a recommendation to the court on down the road. We try to meet at least once a month, and we're trying to move the issues that come before us as quickly as we can through the process that has been set up. So also on my committee is Dan, who's to my right, Daniel Borges. Feel free to contact him. Rebecca Briggs and Adam Ramos are also on the committee. Kevin Fitzgerald, Dana Horton, Joshua Dunn, and Michael Daly. So any of those individuals that you know, like I said, just reach out. And I also want to thank Judge McConnell. Any of you who know and have practiced in front of him know that he's a very involved person, a very involved judge. And it's because he's innovative that he's giving us, the litigators, the practitioners, an opportunity to give feedback to the court. Know what they can do to assist, and if we have a better flow and a better communication with the judges, it's only going to benefit your clients no matter which side that you're on, all right? Just as an example of one of the topics that still hasn't been resolved that came before us, you've probably either heard it from talking to colleagues or seen emails or perhaps a survey about depositions, discovery depositions, and whether or not they should default to being all remote, default to being live, combination in certain circumstances. That is an issue that, in my opinion, is a very hot topic. We have opposing points of view, but there's merit for each of the standpoints. In the Superior Court at their committee level, they're also debating that issue. Neither court has accepted or put into place an amendment to the present rule. But again, if that's something that affects you and you want some input and you haven't participated in the survey, that's the type of feedback that we're looking. So you'll either get solicitation from us to, what do you think about this idea? Or if there's something that you want to present to us, by all means do so. Any questions? Thank you.
Thank you, Donna. And also from the CLE subcommittee, Dan Borges.
Thank you, Eddie. You know what? I'll just do it sitting down. The microphone works for me. So I'm filling in for Zach Mandel. He's actually the chair of the CLE committee. He couldn't make it today, but he asked me to present a few things on his behalf. So the objective of the committee is to develop, organize, and facilitate current, engaging, and comprehensive educational program for the entire bar. And we aim to achieve that through a variety of things, including seminars and what we did here today. We're also responsible for planning the biannual district court conference, which is a key event in our calendar, and that is already in the books as well. And I'll give you some more information on that in a little bit. But the main point here is that we can't do this alone, right? We have a committee, and we could come up with topics that interest me. It's all employment law, civil rights for me, right? But we want to give the people what they want, right? We want you to tell us what you want to learn about, what you think would be engaging and comprehensive. And You can do that in a variety of ways. Sometimes we send out surveys, but you can also contact any of us via email. You can contact Zach or me, and I'll give you a list at the end of the additional committee members. And by way of example, it does work. We sent out a survey a few months ago, and the top 3 recommendations, it's what we're doing here today. And then we have 2 more that I will discuss in a little bit. So your feedback is very important. We want people to be engaged. So any suggestions you have whatsoever, feel free to reach out to one of us and let us know. As for upcoming CLE, so we have this one, and then we have 2 more in the works, and then we have the district court conference at the end of the year. The first one is the First Circuit Appellate Procedure CLE. This is being organized by Joshua Dunn and Tamara Rocha. And this will take place on February 29th, 2024, right here from 4 to 5 p.m. So mark that down. I'm sure an email or notice will be sent out soon. And so this CLE, the panelists will offer practical tips and insight concerning the many stages of appeal in the federal court, including preparing and filing the notice of appeal, assembling the record, so on and so forth. The panelists are pretty awesome. So we have Judge Montecalvo from the First Circuit. We also have Lauren Zurier, who is the Assistant U.S. Attorney and Appellate Chief in the U.S. Attorney's Office for the District of Rhode Island, and Anastasia Dubrovsky, who is the Chief Deputy Clerk of the United States Court of Appeals to the First Circuit. Everybody knows that the clerk is the most important person, right? So that's going to take place February 29th, 2024. It'll be in person. As you know, room is always limited, right? So if you get that email, reserve right away. The next one that we have is the First Circuit Case Law Review CLE. The date has not been pinned down yet. John Fulweller and Stephen Richard are organizing this CLE. It's going to be a unique event. The plan is to have a dynamic panel with a federal judge, a partner from Steve's firm, and then Steve and John themselves discussing, First Circuit case law that's relevant and that applies to everybody, and that practitioners should be aware of. So we don't have a date for that yet, but it will happen soon, and when it does, the notice will go out on that. The last one that we have, and I'm very excited about this because I was really excited about the one we had 2 years ago, and that is a district court conference. So we have a date. It'll take place November 7th from 8 a.m. to 4 p.m., and it's going to be at the Crown Plaza in Warwick. The co-chairs of the planning committee are, we have Hamza Chaudhry right there in the back, and Tamara Rocha again, and Zach Mendel. So this is going to be great because we have some pretty great chairs there. The theme this year is Guardrails of Democracy, Ensuring Access to Justice for All. I don't know about you, but I can't think of a more interesting, engaging, or current theme to have for the District Court Conference. So we have some amazing people on the planning committee. How many people do we have? It's over 10 for sure, right? 22-ish. Way over 10, 22-ish, all right? Some very amazing people with some very interesting ideas, so it'll be a great District Court Conference. Don't miss it. We're excited to be offering all of this. We will be meeting soon to develop new CLEs for the coming year. But again, any feedback, anything that you have, anything that you want to learn about, certainly let us know. We want to make sure that the CLEs are engaging, that they're current again, and most importantly, that you get all your CLE credits for free, hopefully. All right, thank you. Oh, sorry, before I pass this on, the other members of the committee, so we have John Fulweller, Joshua Dunn, Crystal Tadisi, we have Eddie Lee, Zachary Mandel, myself, Pam Chin, Tamara Rasha, and Steve Richard. So you can reach out to any of those individuals with any thoughts or suggestions, and we'll see what we can do. Thank you.
Thank you, Dan. And now from the Criminal Law Subcommittee, we have George West.
I'm going to sit as well so I can read from what I have. Good afternoon. My name is George West. I'm chair of the Subcommittee for Criminal Law and Practice with Probation as well. Kevin Fitzgerald, our federal defender is chief of our office is also on the committee. Pamela Chin, a practitioner, is on the committee, and John Marshall, the chief of the U.S. Probation Office. Natalie Freelander is on the committee as well. I just don't want to mess up her name. And Lee Vilker, the criminal chief. So we have a broad spectrum of people who practice in the area of federal criminal law and affect that practice. The committee has had several meetings since the formation of the council, and I think it's been very effective. We've thought about and tackled several areas that have affected our practice. Doesn't affect everybody's practice, but I was reading the speedy trial plan from the 70s, and in that plan there's a recognition that while the criminal cases represented a very fractional part of the court's practice, they take up, in that time, 20% of the judge's time. I'm sure it's much more period, but so our practice affects everybody's practice, and the more we can do to make it more efficient and effective for practitioners, I think the better off for the court and for our clients. Now, we've had big changes in the United States sentencing guidelines this year that came down, affecting some of our clients in the district and will affect them in the future. So one of the things that we did was we participated with U.S. Probation in putting on a seminar basically reviewing those changes, which has resulted in some reductions in sentencing for clients who had no criminal record in the past or had their sentences increased because they had been on a prior judicial sentence, for lack of a better word. So that would up their criminal history because of that. So the United States Sentencing Commission passed extraordinarily retroactive relief from those two areas under certain circumstances, and continued discretion with the United States district judges to decide what's appropriate in each circumstance. So that was an important development since the council started, and one of the things we did. The other thing that has been talked about often in our meetings was the calendar call, the never-ending calendar call for federal criminal cases, which happens every 30 days if your case is pending. And it makes everyone who's on the calendar have to respond either with usually motion for a continuance or have to go to the calendar call and conference with the judge about the status of the case. This was found to be highly inefficient for practitioners, and I think especially for the court, because invariably cases would have to be continued for realistic purposes. Our cases nowadays are loaded with electronic discovery, which makes it much more time-consuming to go through our evidence and be able to handle the cases, and for other reasons as well. Multi-defendant cases are inherently time-consuming. So the court heard those problems and probably recognized it as well as we all did, and came up with the proposal for a 90-day calendar call. So we were asked to review the court plan, and we did meet with Mike Simoncelli as a committee, and I thought that was, Lynette attended as well. I thought it was a really important meeting, and we had a lot of feedback from both prosecutors and the defense bar about how to proceed. That's all been written up and sent over to the court for consideration, largely in agreement with what the court has proposed. The speedy trial plan has been revised down from, I think, a 50-page document down to something a little more manageable on the order of about 20 pages. And it resulted in a local rule request for a change, or we advised on it, adopting the 90-day calendar call, and how the speedy trial clock will proceed from arraignment right on through the rest of the case, which is an issue right now in the criminal practice. So that's just an overview of some of the things that we've been talking about. I practice on the Criminal Justice Act panel, and I'm the representative for the district to the federal courts that oversee this. So we get feedback from the national programs, and I report back what I learned from that to the panel in the court. So that's my perspective, but as I said before, we have feedback from the prosecutors as well. And it's, having that ability just to sit across the table and talk to these things outside the context of the heat of battle is a really important thing. It's been very effective. So we're happy to hear if any practitioners have ideas that need addressing or would be useful, please contact any one of us. I know we'd be open to that as well. Thank you.
Thank you, George. Now from the Access to Justice Subcommittee, Stacey Nikizian.
Thanks. Before I speak about my committee, I just want to make a plug for the council. It is an amazing collection of practitioners from every aspect of federal practice. And I'm a commercial litigator, so to sit in a room and hear about what affects other areas is really interesting. And when an issue comes up like remote depositions, to hear the plaintiffs' counsel bar speaking of it and bringing up considerations that counter what some of the others were thinking. It's just an amazing experience. It's a really, I recommend it for those of you who aren't involved who might want to get involved. So I'm the chair of the Access to Justice Committee. We have spent the last year basically educating ourselves about the programs that exist and the need that exists, and we focused on pro se litigation and litigants. And we started with a really helpful analysis that Mike Simoncelli did. He did a deep dive into statistics going back 10 years to see the trends of pro se filings, what kinds of cases, what kinds of litigants, and also he tracked how those cases fared along their litigation path, where were they getting snagged, and that really helped inform the committee about what we might do to make the pro se experience more meaningful for the litigant, but also to help the court along in processing these cases. And what Mike's statistics showed was in the past couple of years, 20% of the civil filings in this court are pro se litigants, 20%. And of those, recently, 60% of the pro se litigants are inmate litigants, so prisoner litigation. I had no idea that was that big a percentage of the practice in this court. And we looked at, and Mike did a great job showing us sort of where those cases got snagged in the process. We also looked at what programs had been tried in the past, what programs and resources are currently available. We had a really helpful presentation from the director of the Pro Bono Collaborative at Roger Williams. They're doing amazing work, including specific programs they've run with this court in the past. And that also informed us as we are thinking about how to prioritize where we might put our efforts. Based on all of that information, we've identified a couple of places that we want to work on going forward. So in the year ahead, we're now going to get going on the initiatives that we've identified. One is the court's website. The court has a fabulous website, and it has great information for pro se litigants. But as we looked at it, we thought that the language maybe could be made a little user-friendly for non-lawyers. So we're going to be focusing on making recommendations to the court about how that language might be changed and worked on. We thought a lot about forms, because there are forms available on the website, and forms can help pro se litigants. But we learned that the First Circuit has a project undergoing currently with Suffolk University, and they're developing forms. So we kind of backed off on that one and made ourselves available to that project as needed, but we'll be interested to see what comes out of that. So we sort of put forms back on the back burner. We learned that the court had a pro bono clinic. I wasn't aware of that it launched just before COVID, and it operated for a short time, and then COVID sort of derailed it. Hasn't been restarted. it essentially made attorneys available on an appointment basis to pro se litigants who had a particular question, procedural or otherwise. And we heard from attorneys who had participated in that, how it worked, maybe some things that could change. And we're looking and discussing with the court and determining the resources involved in maybe restarting that. One thing we learned was litigants come in and they pay the filing fee and they file a complaint only to find they're in the wrong court, which creates work for the court, creates financial burden on the litigant. So even just having someone at the intake level, because the clerk's office, of course, can't give legal advice and is constrained in what they can do, but the private bar can help in those moments. So as you'll see as I go on, we're looking for these sort of touch points where members of the private bar could provide assistance. And I'll just, as a side note, one of the things we all acknowledged in this committee going into this was we don't have a great pro bono ethic here in Rhode Island. I mean, of course, many lawyers are doing great work, but just as a part of regular practice doing pro bono work, it doesn't seem as vibrant here as in some other jurisdictions. And people are busy and spread thin, so we're trying to think of ways that attorneys could do this sort of work without too much of a commitment. So sort of limited representation times, as in the pro bono clinic, that they can come in and help. Another place we determined was an issue for pro se litigants was at the motion to dismiss stage. So we're looking at whether attorneys could just have a limited representation in that stat stage in the litigation to offer advice and an assistance without committing to staying with that pro se litigant for the entire case. Another area that we're very focused on is mediation. Natalia Freelander did a great job sort of canvassing the experience of pro se litigants, specifically inmate litigants, in the mediation process, and learned that mediation wasn't really succeeding for that constituency because they didn't understand it and they didn't trust it. And we all know that, you know, unless you have buy-in to mediation, it's not going to work. So we're looking at a program where private bar members could consult with pro se litigants before the mediation process to make sure they understand it, how it works, build some trust in the process, or even representing that party in the course of the mediation. So that's another area we're going to look at going forward. It's a great committee. We are happy to have more people involved, and we look forward to setting up and finding ways that the private bar can plug in and assist and make pro se litigation a little more accessible and access to justice improved here.
Thank you, Stacy. And now the chair of our DEI subcommittee, as well as the chair of the Judicial Conference this fall, Josh Xavier.
Thanks, Josh. Good afternoon, everyone. It's so awesome to see all of you and so many familiar faces. Just a quick clarification. I served as the chair of the conference for the last conference, not this upcoming conference.
Great job.
Thank you. But we actually have far better chairs for this conference this year coming up. So my name is Josh Xavier. I'm the chair of the DEI subcommittee. First and foremost, I just want to say thank you to Judge McConnell for giving us this opportunity to have input into the court, its operations, how it runs. Really awesome. I'm not so sure there's any other jurisdiction that has a council like this. So thank you very much for this opportunity. So DEI, right? What does it mean? I think we live in a society where everyone has a different definition for DEI. And so what I asked the members of our committee to do at our very first meeting was tell each other what DEI means to you. And what does diversity mean to you? What does equity mean to you? What does inclusion mean to you? And so what I thought I would do, which would be beneficial to all of you, is I'm going to share some of the comments made by some of the members of our subcommittee as to what DEI means to them. Because what DEI means to each member of our committee is really the platform for our committee. And it is forming our operations and it's forming our mission. So here's what members of our committee had to say. One member said DEI equals strength and is important for the future of the judiciary in the country. One member described it as a triad of principles: who, how, and by what means. One member said it was shining a light on and working to correct historical wrongs. One member described the importance as bridging the pipeline between those with power and those without. One member described it as what types of people are at the table, can they hear at the table, and can they have a say at that table. One member viewed it as a lifeboat because it's an open boat and no one does well if they aren't helping each other. One member said that civil rights attorney Fred Gray, who represented icons of the civil rights movement, including Dr. King, Rosa Parks, Congressman John Lewis, and who was the keynote speaker for our court's district court conference last year, he embodied DEI for that particular subcommittee member. And lastly, one member said that DEI to him meant creating opportunities for members of the bar to better understand historic and present-day institutionalized and systemic discriminatory laws, policies, and practices so that they can work to create a more equitable society. Again, I say all that to really point you in the direction as to what direction our committee is moving forward. So we spent the bulk of this past year working on one particular initiative, and that initiative is what we're calling a demographic questionnaire for members of the bar to complete. It's going to be extremely similar to the same questionnaire that the Commonwealth of Massachusetts invites its members to complete. So if you're a member of the Commonwealth of Massachusetts bar, you know exactly what I'm talking about. It's a questionnaire that really dives deep into what makes up its bar: race, gender, sexual orientation, disability status, whether you're a caretaker, those types of demographics. And so what we have done is we've created our own questionnaire. It's very, like I said, it's very similar to the Massachusetts questionnaire, except that there are 2 additional categories of questions that we have added to the Massachusetts questionnaire. Number 1, we are going to ask if the attorney identifies as a first-generation attorney. Not only are they a first-generation attorney, but are they also first-generation college graduate and high school graduate? So we're going to see the layout of the landscape as to how many members of our bar are the first in their families to graduate from high school, college, law school, etc. The second question that does not appear in the Commonwealth's questionnaire that will appear on our questionnaire is national origin. So we plan on asking, what is the attorney's national origin? Again, the purpose of the questionnaire will be to really discover what is the makeup of our bar, who do we look like, where do we come from, what areas of the law do we practice in, how long have we been practicing. And so we're also going to use that information to try to create programs, resources, and support to further implement diversity, equity, and inclusion. And so after we get the results of the questionnaire, we are going to follow in Massachusetts' footsteps. I think Massachusetts has done a great job with this. What Massachusetts has done is they've taken the result of their questionnaire and they have created a document that compares the demographics of the Massachusetts bar with the general population in Massachusetts. So you can see if there's a gap between what the bar looks like versus what the general population of Massachusetts looks like. And so I'm just going to share a few statistics, not all of them, and I'll share with you where there are some gaps between the Massachusetts bar and the general population. So, number 1, and this is all from the Massachusetts 2022 questionnaire. Number 1, disability status. 3.9% of Massachusetts lawyers identify as having a disability and or as neurodivergent, whereas 12.5% of the general mass population identify as having a disability and or as neurodivergent. That's a difference of 8.6%. Gender identity. 44.5% of the Massachusetts lawyers identify as female, whereas 52% of the Massachusetts population identify as female. That's a difference of 7.5%. Then finally, when it comes to race and ethnicity, 2.3% of the Massachusetts lawyers identify as Black or African American, whereas 6.5% of the Massachusetts population identify as Black or African American. That's a difference of 4.2%. When it comes to individuals who identify as Hispanic, Latino, or Latina, 3.2% of the Massachusetts lawyers identify as Hispanic, Latino, or Latina, whereas 12.6% of the Massachusetts population identify as Hispanic, Latino, or Latina. That's a difference of 9.4%. And so I share all that with you to give you a preview as to what we would like to do with the results of our questionnaire. Our second initiative is actually tied to the questionnaire. The second initiative is a mentorship initiative. The goal is to see the results of the questionnaire, identify the gaps that I talked about, the gaps between the makeup of the federal bar versus the Rhode Island general population, and to dive into those underrepresented groups and to create a mentorship program designed for those underrepresented groups in order to increase their representation in our bar and to decrease that gap. And so what we have proposed, and Mark DeSisto has been extremely involved in that process, what we are proposing is something along the lines of an informal mentorship program where if you're an attorney, if you're a judge, if you are a member of our court and you work in our judicial system, if you would like to have a mentee, if you would like to really get involved in the life of a young person, expose them to your work, expose them to the law, and possibly inspire them to become an attorney, this would be your opportunity. We're trying our best to have a balance. On the one hand, we do want it to be involved and we want it to be worthwhile, but at the same time, and I think someone else made a mention of this, we don't want to spread people thin. So we're trying to figure out, what are the minimum requirements for a mentor in this program, because we definitely want there to be a productive mentorship where mentors are really investing in the lives of young people. And lastly, our third initiative is really tackling what are the DEI-related impediments to joining the bar. And as we all know, in order to become a member of the federal bar, you have to be a member of the state bar. So really that group, most of its work is diving deep into what are the DEI impediments to joining the Rhode Island State Bar and what possibly could be done about those impediments. That group has met once, and so we're excited to see what that group produces. I'd like to think we practice what we preach, so if anyone would like to come to a meeting, join our subcommittee, we are totally open, extremely inclusive. There are 3 subgroups, and then there's one subcommittee. The subcommittee meets every other month, usually on the second Mondays remotely. And I can't stress this enough. If any of you have any ideas regarding diversity, equity, and inclusion, please don't hesitate to reach out to me, Mark, Lynette, members of our subcommittee, Adam Ramos, Crystal Tedeschi, Jason Dixon Acosta, John Fulweiler, Dan Procaccini, Eddie Lee, Cassandra Feeney, and Mark Morse. Thank you all very much. I really appreciate hearing your input for our DEI committee. Thanks.
Well, hello again. So this always happens. I wanted to say something and I forgot to say it, so I'll just say it. So, there's really 3 groups of individuals that are coming together to help here. So it's the bar with this council, it's the judiciary, and from that chair, I keep looking at Nora, who just does a tremendous job, and her staff, they're unbelievable. What a Mike Simoncelli, Frank Perry, all of them. So they've got such information for us, and they go out and do everything we ask and compile data. It really is something. So I neglected to mention that, so I wanted to. This is great.
Mark read my mind. I was thinking the same thing, and I mentioned to Nora, which I believe it's pretty incredible, that when you ask the staff for something, you never get a no. They just go out and figure out how to do it and give you what you need, and it's incredible. So thank you.
Well, thank you, everybody. Are there any questions from the audience or from Zoom land? Going once, going twice. I think we have hit our mandatory 50 minutes, so let's give a round of applause to all of our chairs and to Mark and Lynette. I believe there are sandwiches in the back. If you're on Zoom, sorry, no sandwiches for you, but
No, I would say I know 70%.
Why don't we get started?
I'm just gonna start talking, and that'll. And now the program is continuing. Okay, hi, good afternoon, everyone. Hopefully you've all enjoyed your lunches. Exactly, yes. And
Total silence.
good to see you. No, no worries.
I've
Good,
done
how are you? And now for the second half of our program, for those of you in the room, there will be ample time. If you have any questions, feel free to raise your hand. We have microphones floating around somewhere, and if not, I'm happy to repeat your questions so that the world of Zoom. Yep, Nora has 2 microphones. And if you are in Zoom and would like to ask a question of our distinguished panelists, feel free to throw a question in the chat. But besides that, the impetus, or rather the thought behind the second portion, is that the Federal Court Advisory Council has questions for you all. And so the different subcommittees put together a few questions from each of its members that I thought I could present to you, and to the extent you're interested in answering, hopefully you are, and you have something you'd like to express in response. So that's the format for now, and if it goes poorly, blame me, and that's fine. Okay, so from our CLE committee. What CLEs, in addition to the ones we already have, would you like to see provided? Any other programs that you think we should provide? Not all at once, just one at a time,
I actually have a question more for the group that's here. I have often envisioned that the court should offer enough free CLEs through the federal court that you all can meet your state obligations for it, and there's no price tag to it. I can remember I was always late with it, and then I'd have to find one, in December, and it cost me a few $100s, and I had to sign up for it, and I didn't care about the topic, and that was kind of my experience with CLEs. So I've often thought that it would be a really good idea if we put on like a lunch and learn once a month, at 40-minute topic of interest, give everyone, I don't know, how many CLEs do you have to do now? 12 a year? 10. Just to give you that opportunity. And I just didn't know if that's still or is a problem with the bar and with your colleagues, which is the cost of CLEs and getting them done in that way. You all are rich and famous and don't have to worry about that. And
We have
you
some
all-
microphones in the back if anyone wants to jump in. Anything from Zoom? No?
I used to go to something with the stars, it was called, and it was at the Waldorf Astoria in the second week of December. Atla put it on, and I kind of got addicted to doing that for a while, but boy, that was expensive. But you got all your CLEs done.
Hold on, there's a microphone coming to you. Hold on a second.
I recall in the Superior Court, they used to have food for thought seminars. They were 1 hour. I think it came with food. And they were very useful because, to take an hour out of the day, satisfy a CLE requirement, and it being on a topic that you're interested in. I took advantage of that. So I do think that those those short luncheon seminars is a good idea, and I frankly had forgotten about it until you mentioned it right now.
The food for thought seminars were excellent. We also used to do I don't know if it was but a Supreme Court year in review update at the end of the year, and we did it with pizza and whatever, and we did both civil and criminal cases. It was primarily a criminal thing attended by a variety of people, but I think something like that, sort of a very quick, somebody has to take responsibility for reading the important cases that come out, or several people, and sort of just summarizing, okay, here's what came from the Supreme Court this year. I see George West here, he probably still attends Supreme Court year in review, or whatever they call it. But it was a couple of hours with pizza, and, I don't know how something like that would work, but
I got a thought. Well, first of all, I would say that, we have the Litigation Academy, which I think is a really good vehicle for CLE on the skills side of the equation, and we're always in the group that, and we're broadening that group that kind of plans at Brooks, and Nikki Kukas from the law school are still chairs of it. Carolyn Murphy's going to take a more significant role, and so we're trying to get some younger people in that. But I think we're always looking for ideas on what are the skills, skill-enhancing programs that might be helpful. And there's a lot of CLE credits for one of those Litigation Academy programs. I forget how many they come with. Brooks, how many? 10 to 14 for just taking one program. But one thing I think we could think about doing is more on the substantive law side of things. So, we could pick a couple of topics during the year that look really interesting, and combine members of the court and members of the bar, and maybe do a lunchtime or a 1-hour program. One that's just really fresh in my mind is on the status of the Chevron doctrine, because that was,
It's on your mind.
yeah,
We gotta wait till we know the answer.
right. But it was
Judge
just
Smith gave us the answer.
it was just argued, and the case came out of, it was one of my case, and went to the First Circuit, and that was just argued 2 days ago, I think, in the Supreme Court. And it's pretty clear if you listen to the oral argument, Chevron is going to change, and it's going to be something else. So, that would be an interesting program. But stuff like that, where, the law is evolving and changing, and maybe just pick a topic and get some people who really know what they're talking about, it might be a good way to tap into the law school, too.
Anything else from the George? There's a mic coming to you.
I can see that happening in terms of agencies in interpreting their acts that actually result in criminal charges. And also I'm thinking of the food stamps cases where agencies are applying the law as said by Congress, but becomes much more intensive in their regulations. So I think that's really something that ought to be done as a topic. Thanks.
Great.
John had a comment.
I would just add that in terms of recruiting attorneys to present these seminars, it's a lot easier to present a food for thought seminar, which I've done, than a year in review, which I've done. I used to do that for the Bar Association October program, and I gave it up because I just couldn't do it anymore. It was too long. But to do a 1 hour, you'll, I think, have a lot more success recruiting attorneys to present.
Some good food for thought, I guess, on that one. Yeah. I'll be here all next hour or so. Anyway, taking a leaf from Josh Xavier's book, who he had asked the members of the DEI subcommittee what they thought, what DEI meant to each of us. And so I'd like to now throw that to you all. What does diversity, equity, and inclusion mean to you?
I found Josh's list so daunting that I thought, how would I come up with an answer to that question? So a couple of things. tapping into the last conversation, I think one of the food for thoughts really ought to be on the Supreme Court's affirmative action decision, and how does that impact, for example, us as a court, in thinking about how, to what extent can we be affirmatively thinking about race? I'd love to get some guidance on that. So back to your question, I think for me as a judge, the concept really reflects an obligation to be aggressive and alert, and in some environments, and now is one of those times, I think, to be very aggressive about remembering the impact on litigants, lawyers, law clerks, employees, and people of their backgrounds, and how those so differently affect the ways that they present when they find themselves intentionally or unintentionally caught up in a federal court proceeding. And how do I keep the way that I relate to those people as open and inclusive as possible? How do I educate myself to have empathy for those very different circumstances that people are bringing as their baggage or their benefits as they appear before us, and that it's harder work than you think?
I would echo what Judge Sullivan just said, because we have to make difficult decisions about people in criminal cases that involve behavior and environment that often is different from the environment that we're in, or the behaviors that we find to be acceptable, or things we see in our everyday life. So I really have to be mindful about putting things in context and trying to understand better that everybody is different, and that just because somebody is behaving in a way that's not consistent with what we would expect, that doesn't mean necessarily that it's bad. It's a difficult thing to do, and some of the defense attorneys in criminal cases have made that point to me over the years about be mindful of some of the challenges facing others that you might not face. So I think that's something we need to embrace and be comfortable with.
I guess I wouldn't attempt a definition. I actually thought Josh's list was about as all-encompassing and articulate, far more so than I could be. Randomly, some things that come up that I think Judge Smith a few years ago made us very aware about the issue of implicit bias, particularly with juries, and how do we address it. And for a while there, I don't know whatever happened with that, but a while there we began to work on a jury charge that might work. We talked about this an implicit bias video that I think somewhere out in the Ninth Circuit shows jurors, and a number of issues about implicit bias in the courts and how it plays in, witness memory, even, and it's not even just the bias of the jurors. It can be racial implicit bias in witnesses or eyewitnesses or whatever it happens to be. That's an issue that I think we should delve in. I mean, if we had more jury trials, we probably would prioritize it more, but because there aren't that many, it may not have been as big a priority. I think that's a huge issue that there's data on, there's good science on, that we should be working on. I mean, the other thing is, it's really disconcerting that when the majority of the people that come before us in handcuffs and chains tend to be people of color. It's just a fact. And they're confronted with a predominantly white institution, from right now all the judges and a lot of the staff. And I don't think we talk enough about the impression that gives off. The national state courts something, NS something. I can get it for you. We could put it up on the website. Just did a massive survey across the country. Now, this is of state courts. The gap of people trusting the judiciary on basis of race is dramatic. And assuming it's good data, which I'm going to by the organization that did it, that just screams out to me that we've got something to do. We've got to figure out a way to legitimize ourselves amongst a segment of a population that statistically doesn't see us as legitimate. So that's something else I think we have to look at. I think in the criminal context, I think we've got to look at Batson and how Batson hasn't been as effective. And I mean, you all know, this is coming from a former plaintiff's trial attorney that loved voir dire and loved my preemptory challenges, as you all do that try cases. I think we've got to seriously look at whether we can continue with preemptory challenges in a way that is not race-based. And I think that's something that we should all collectively look. These are all topics, I think, by the way, that are perfect for the bar and the advisory council, whatever, to, the really kind of tough issues. I can't believe I would ever say that, but I do think at some point when we see Batson really not working the way we all hoped it would, whether that's something that we have to take a look. Colleen Murphy, the professor at Roger Williams, has a deeply held belief founded in academia that preemptory should be abolished if we really want to work on this. But anyway, those are just some random thoughts along DEI that I know it wasn't very compact and articulate. But.
I just endorse everything that these guys have said, but I would add this. To me, it's all about like looking for opportunities and then capitalizing on the opportunities. And implicit bias was a good example of that. Was there an opportunity to develop a jury instruction? There was. I gave it in a trial. That was an interesting experiment, see how that worked. We talked about doing the videotape from the Western District of Washington, show it to our potential jurors. That's an opportunity. And maybe a most dramatic example of opportunity is getting Melissa DuBose to apply for the district court. There's, that, I mean, maybe she would have applied, but maybe it was more likely that I corralled her at his house and then pulled him over and said, help me out here. And we had a real, heart-to-heart conversation with her. Go for it. And, she did, and now she's been nominated. So, I mean, that's an opportunity. You don't know how it's going to work out, but I think you just got to have that mindset of my mind is open. If I see a chance, I'm going to do something, That's, to me, what it is.
So I get to go last. So, and Judge Smith just stole everything I was going to say, and particularly about Melissa DuBose. I will admit to a bit of strong-arming of Melissa and others. And I feel like it's one of those things where, they've done studies by gender, I know, and probably by race, that men will apply for a job if they meet 60% of the criteria, something like that. Women won't apply unless they meet 90-something% or more. So it's for those of us to say to people like Melissa DuBose, but others as well, hey, put your name in. You're a legitimate candidate for this. We talk about things in terms of qualifications. The only qualifications for a district court judge are that you be a lawyer, and I think you had to be one for 12 years. Is that right?
That's the unwritten rule.
Oh, that's not even a qualification. Just a lawyer, and in good standing, I assume. So, start reaching out to people who are not typical and encourage them to apply for not just judgeships, not just magistrate judgeships, but boards and commissions, and law clerks. We need to support people and say, you need to put your hand up, because until we get people to put their hand up, a little push or a lot of push, then we're not going to diversify anything. So.
All right, thank you. Something a little less heady from the local rules subcommittee. What are some inefficiencies you've observed, and what do you think that you'd like addressed and perhaps changed through a rule change?
You've got a long list, Judge Sullivan, I can tell. Go for it.
Oh, I don't know. Well, one inefficiency, but I think we're working on it, is when dispositive motions are referred to us, the time and work for that to move from beginning to end is essentially doubled. And I realize the second bite principle is the pushback there. And just because we think we're brilliant, well, actually we know we're brilliant, and we know our decisions are always correct, so why get a second bite when you've already got the right answer? That may not be possible. That's actually a frustrating aspect of the way that I think a combination of the way that the statute requires things to work, and then the practice in this district of motion by motion referrals leading to those motions that get referred go through this double trouble life expectancy that takes twice as long. I don't see a solution. That said, maybe the brilliant guy on my right.
Well, I'm not brilliant and I have no solution, but I do think as judges and as a bar, we should be more open to thinking outside the box about cases and disputes at an early stage, and whether there are legal issues that can be decided early on that might affect how the case moves forward, whether things, procedural matters or discovery matters, can be addressed through more informal means. We've done some of that, but I think we could do more rather than having a lot of time, money, and delay built into briefing. Many times, once I digest all those briefs, there's just a single or two questions that need to be decided, and not a lot of precedent out there, and somebody just needs to decide it. And I think to myself, if we were on a Zoom conference and just talked about this for a half an hour, we could have teed the issue up without all this time and money. So I would encourage, I don't know if it's something the local rules could address through more informal briefing, more informal conferences to deal with disputes, but also encourage lawyers at Rule 16 conference or to jointly request conferences to discuss issues, to say, hey, we need an answer to this. Let's talk about, because all of us can adopt, if you propose a process to get to an answer, we can just order it. If you propose it and everybody agrees to it, or if you can't agree, we can fill in the gaps where you don't agree and come up with a process to get you an answer, because we have fewer trials here than when I started 20 years ago, and our caseloads, I haven't tracked them, but I'm guessing they're not going up because of the expense of litigation. It just seems to be, to me, out of control. So any way we can improve efficiency, reduce cost through either local rule or just thinking outside the box together. And it's so easy now to have a conference. If you contact the court and counsel reasonably set forth, we think we need a conference and here's why, with Zoom, we can squeeze those into our calendars pretty quickly. We're pretty flexible and nimble now to do that. And I think if we all think about this, because I'm sure the cost of litigation is a challenge for all of you and your clients day to day. I mean, if you do things that result in bills that are disproportional to the case, that's a problem. But sometimes you end up having to put that time in to do it correctly. So I guess I would advocate for anything we can do through the rules or through just cooperation and collaboration to move things faster and cheaper.
So I'm just going to jump. I'm sorry, Judge.
I was just going to riff on that a little bit because, I think an example of that was I started implemented a policy that said you can't file a discovery motion unless you have a conference. And I think I probably brought the number of discovery motions down 90% by doing that. Everything gets worked out in conference. Period. Once in a while, a motion gets filed. Almost never. And it's just we work it out on a Zoom. The other thing I was going to say about this is for a long time I've kept the graphs on the statistics about trials in the federal courts and in Rhode Island. And we just updated the graphs, Michael Simoncelli did, and I was just looking at them the other day. The number of trials now, I mean, it's almost impossible to imagine. It almost can't go any lower, because if you look at the graph coming down from the 1960s, it's so close to 0% now. The percentage is between 0.5 and 0.7% of cases tried go to trial. So that's where we are on the civil side. And I know I haven't had a civil jury trial in maybe 2 years, several during the pandemic, but it's just almost gone. So what do we know? I talk to the lawyers on Zooms all the time. We know you're not going to go to trial, okay? I mean, statistically speaking, you're not going to go to trial unless you think that you're the...
Did you hear that, Mark?
Right. If it took Mark and his firm out of it... So, if we just look at the case early on and say, all right, what do you need? Just like what Judge Alman's saying, what do you really need to figure out how you're going to resolve this? Because you are going to resolve it. Now, maybe you got a good summary judgment motion. Maybe you can clean the case up a little bit, get some counts dismissed. Okay. Maybe what you need is a decision on a few things. Fine, we'll do that for you. Maybe you need a couple depositions, maybe some written discovery. But we all know that you're gonna work this case out. That's the likelihood. So if we could try to, just figure out how to streamline all the formality of discovery and just kind of get down to the, brass tacks early on, figure out what you need, and then let's get you into a good, a good process to get this thing resolved, mediate it, and get it done. Because, then I think these cases would be done sooner and more efficiently for your clients.
Can I, obviously the newest person here and the only one who came from a criminal background. So I've been here for a little over 4 years and I've had 10 trials, 6 of them jury trials, 5 of them civil, and then my 4 non-jury trials were civil. So whatever you're doing to try to avoid trials might not be working as efficiently in front of me as it is in front of my colleagues, so you might want to change your game. But one of the things that really drives me nuts, and I haven't figured out how to deal with it, is people who don't really engage in the Rule 16 process. And I come from a place where I know when judges would say, well, you need to be ready in 2 weeks, and I'd say, my expert isn't going to have the DNA results for 6 months, that you're just going to continue at 2 weeks, and in 2 weeks I'm going to ask you for 5.5 months, and you're going to complain, and we're going to go through this. And that's a waste of my time. So I find it's so frustrating that everybody seems to think they need 6 months for discovery, and at the end of that 6 months I get a continuance and another one and another one. And I've kind of, my colleagues are all very nice, and I try to be, but I've talked to people in other districts and they said, we don't give continuances. Now, I don't want to take that position, but I wish that you would be more authentic about what you need earlier on. And when you're asking for continuance, don't ask for 30 days if you need 9 months. It's a waste of my time to look at those motions. It's probably not the biggest inefficiency built into our system, but when people unironically file things that are called eighth joint, motion to amend scheduling, whatever order, I think, okay, well, somebody's failed. It's probably me, but I'm still working through how to maximize that process. So I'm not going to automatically deny motions, but at some point we need to be a little more authentic about those things. So
So when Judge Elman raised the point about communicating and reaching out for some type of conference, I saw a lot of head nods. So is that to say that if anybody here or in Zoom emails with opposing counsel asking for just a check-in, that would be welcome? Okay, great. So that's your takeaway for today, I guess. All right, thank you. So from the criminal subcommittee, there's a rumor going around that the court's considering changes to how it conducts calendar calls and sets trial dates. The criminal subcommittee is supportive of the effort, but wondering if the court has plans of what the new process will be, considering the laughter maybe.
Beautiful statement of the question, but that has been in discussion and was the subject of what I was talking about before. I'm sure the court might add to it. That question is sort of in the works of being resolved.
Well then, good, I guess. Moving on.
I don't want to spend a long time on it because I think, unless I'm wrong, I don't know all of you, but I know most of you. George might be the only one that practices criminal law. Do other folks practice? So we can have a conversation off, but basically we have this competing issues of the Speedy Trial Act and the court's operation, and most importantly, defense lawyers that need time to get properly ready to defend their client. And so just from an administrative point of view, instead of every 30 days, continuing it for another 30 days and 30 days and 30 days, Mike Simoncelli, in consultation with the Advisory Council and others, came up with a 90-day system so that cases can be continued 90 days, still honor the Speedy Trial Act, but not require so much meaningless paperwork to continue it along the way, because the defense bar primarily told us that the Speedy Trial Act in the vast majority of cases is not an issue. It's not where people are clamoring to have their case. It's more like defense lawyers are clamoring to have the time to prepare than anything. So we've just, I think we've either just implemented it or we sent it out to Nora? Yeah, so all the suggestions that have come through, they come from the Advisory Council, they come to the court, the five of us meet, we say yay or nay after the input, and then they have to, by statute, they have to go out for comment to the public. So you will shortly be getting a notice, and any of these things like that you want to comment on, because then it comes back to us with all the comments. And we've actually changed a few things I can remember over the years based on comments from the public in general. So that's kind of where we are on that. It's that balance of efficiency and rights, and recognizing that. I don't mean to get my colleagues mad at me here, but look, we're here 9 to 5. We're getting paid, right? We're public servants. It's you folks that have the schedules and the time and the ability that it's really you folks should be figuring out how can you become more efficient, that therefore allows us to be more efficient. Like I said, I mean, if it takes forever, I'm getting paid anyway. I'm here, and nobody gets on me when my cases or whatever in a way. So what my whole goal in this advisory council was to realize that we really are partners in the administration of justice. Like, don't come near me on substantive decisions. I protect the judiciary's and the judges' independence completely. But you're partners with us on the administration of justice, which is everything else. And it really should be focused from our collective perspective. An example, I hate our local Rule 56. I just hate it. I hated it when I practiced. I hated it when Judge Smith made me do it and told me to suck it up. I hate it as a judge. I consistently hate that statement of facts. I've told many of you this, I personally found the local Rule 56 useless to me as a judge. My old style was you do summary judgment, you state all the genuine issues of material fact, you attach an affidavit that has all of the exhibits and the interrogatories, the documents, whatever, that show that dispute. The other side does the same, and the judge decides it. Now we take the arguments, and then we have this fact thing out there that, with all due respect to almost all of you, no one does it really well and right. Almost none. I know Judge Sullivan occasionally finds something. So anyway, All I'm saying is look at how we're partners in that, right? If it's not useful for me or the judges, they don't all agree with me. I'm just telling you, it's just me. And I keep hearing from the bar, I heard you all kind of laugh about the Rule 56 requirements. You don't find it very effective. What the heck are we doing it for? So when things like that, to make ourselves more effective, to make us more efficient, to make us more helpful to you in your practice, we've got to engage in this kind of partnership back and forth on the best way to do it for all of us collectively. It's like the deposition rule. Like, I don't care whether depositions are remote or not remote. It doesn't affect my cases. It doesn't affect my life at all. It's like, what do you guys want? And that should be what's driving it. And I'm hoping, as we establish this advisory committee and more permanency and it gets more legs under it, I'm hoping that's what it becomes. So, all right, you go ahead and disagree with me, because I know you like those summary judgment motions.
No. I'm good. You can get rid of them. Do whatever you want.
Yeah. Guess who's retiring? Yeah, whatever you want.
So if attorneys approached you in a case that's before you and said, we'd like to do dispositives, but we don't want to do the statement of undisputed facts?
I would consult Judge Smith with that. He may not remember this. That happened about 7 or 8 years ago. And he said, fine, if you want to be overturned by the First Circuit, go ahead and agree to it. That's what you did say.
Yeah.
Yes.
Never mind.
I would consider it. Yeah, I would consider it.
Okay.
In the right case, I would consider it.
All right, from the Access to Justice Subcommittee, there's a curiosity going about the current status of the docket before the district court right now. Is it backlogged civil, backlogged criminal, no backlog? How COVID affected? What's the docket looking like?
We all have about a little above or a little under 200 cases. The 3 judges, and then these 2 have 600 divided by 2 in that regard. Civil. I think we're lower than we've been, but I think it's actually began the last 2 years. I think it's beginning to tick back up again. Civil filings. I think that you've probably looked at the data sooner than more recently.
I think it's really lower than it's been in a lot of years, actually, overall.
Yeah.
I think our caseloads are generally trending down, and so.
Do you feel we're backed up? Do you feel we get opinions out timely? Yeah, none of you are going to say no.
I feel I'm backed up and I don't get things out as quickly as I'd like to, but that's also just me. So.
Is Steve McGuire still here? Yeah. Poor Steve.
I mean, we have fewer. The truth of it is, we have far fewer cases per judge than the average caseload of district judges nationally. I think the average is around 450 or 60 civil weighted cases. We have we're in the 180s, between 180 and 200.
But that's not weighted. We're actually, if you compare apples to ours, we're somewhere in the mid to high 200s weighted.
Oh, is that right?
Yeah.
Okay.
Yeah.
All right.
We're not that low.
So maybe, but would you agree we're in the lowest 10% nationally in terms of our caseloads?
Yeah.
Yeah. So
take advantage of it.
Part of your question was about COVID.
Yeah.
And we plowed along on the criminal cases during COVID, and I don't think there was any significant backlog. And it was a bit odd to me during the pandemic. Some cases in the civil side just plowed along as if the world was still fine, and others came to a screeching halt, and I think it was attorney-specific, or maybe even type of case specific. So there are some older cases on the docket that I would suspect are still around because of COVID delays, but I don't think it had a huge impact on the docket overall.
I do have a question, if anyone would be willing to speak to this. I do have the sense that the overall caseload that we have now on the civil side does not have as many complex cases for variety of kinds of complexity, but that it's a different kind of caseload than it was, say, 10 or 20 years ago. I have some thoughts about it. but I can't prove any of them. But I'm wondering if any of you, as you're the ones filing cases, and I'm curious if you think that's true and if you have any theories as to why. And it could be that I'm just wrong about it, and I'm imagining
Raina
that.
has an answer. She's standing up.
Sorry. Can anybody have any thoughts about that?
I'm just going to throw out this theory that's occurring to me now, but it also has to do with the idea of cases settling. I think when the rules of civil procedure were adopted with discovery, the theory was that if both sides of the case are seeing the same evidence and there are reasonable lawyers on either side of the case, they're going to come to a conclusion and come to an agreement. I mean, I think the rules of civil procedure were designed to foster agreement and to be self-executing without the need for a trial. And I suspect that the same may be true with respect to the complexity of cases. There's so much settled law. I mean, you know, in the area that we practice with a medical malpractice, the law is so settled and the rules are so clear that the only area where there's some complexity is in Daubert, you know, with the introduction of Daubert. And even that has dropped off because that law in that area has become more settled. So that's my theory anyway.
One's coming to you.
I'll just offer one hypothesis, which is I'm seeing more and more contracts are not including, nobody's picking Rhode Island as the forum and jurisdiction. It's New York, Delaware, New York, Delaware, and you're like, how about Rhode Island? They're like, New York, Delaware. So I don't know anything about that. I mean, I don't know that factors into what you're saying, Judge Smith, but I'm just seeing that.
Interesting, yeah.
So I don't think I can talk about what happened 20 years ago by any stretch of the imagination, but from just looking at my caseload over the last, 5 to 7 years, I don't think our cases are that complex. Where I think the complexities are happening are you're taking relatively straightforward cases and building out these discovery requests that are so unwieldy, and you're making something so much bigger than it actually is, when in all actuality you probably get discovery done in 6 months, but for the fact that opposing counsel is asking for the sun, the moon, the stars, and let's go all the way out to Jupiter to get what you're looking for, and it doesn't actually have any bearing on the outcome of the case. You're just doing this massive discovery lift for not a really good reason. So I don't think the cases are that, especially right now, I don't think they're mostly that complex. I think it's the discovery that's making them really challenging and, at least from my perspective, sometimes very frustrating.
John? Unlike Katie, I am old enough to have a perspective on how it used to be. And I'm not sure why this is, but in our area, I've seen a huge drop-off in product liability litigation. And coming from where we come from, I might attribute it to the deterrent effect that all of the prior litigation has had on manufacturers. When I first started practicing, there were flammable fabrics cases pending all over the country. Lenny Diekoff used to travel around trying them. Those are done. The big auto defect cases, the Pinto and the exploding gas tanks, and we don't see them anymore. And perhaps it's just that manufacturers are making an effort to keep themselves out of the courtroom. I don't know. I was talking to a defense lawyer recently, and he told me that one of his insurers has a no trials policy. They will bend over backwards to keep a case out of a courtroom. And that goes back to the old adage that when there's a trial, someone is going to leave the courtroom very unhappy. Whereas if you have a mediation maybe you both leave the mediation a little unhappy. And so mediation was unheard of when I first started practicing, and now it's the rule. So no trials. I do want to say, given my age and the time I've been practicing, I can remember a time when I didn't want any of my cases here in this court. And now it's turned 180 degrees, where I'd like to have all my cases here. And I think that is a tribute to how you all have basically turned this into such a user-friendly place. And I know the members of the trial bar that I speak to feel the same way. So it's a good thing. I don't think that it's going to result in more trials. I think that's a trend that isn't really going to change.
I've been asking a number of questions, but if there are any questions that come to the mind in the audience, anyone from Zoom, I can keep going. Oh, right there.
It's on a big topic one. And first, I just want to just sort of follow up Katie by saying my clients deserve the sun, the moon, and the stars. So, okay, all right. Just wanted to make sure. So this is a question just to get back to sort of the set of commentary around the DEI question. And I think it's been helpful to see the discussion evolve over the years and really exciting. I remember going to the workshop in this room about implicit bias, very interesting thoughts about jury selection and Batson. And I guess I want to start out by saying, okay, representation does matter for sure, and it is important. And I'm not trying to say it doesn't at all. And just, I'm going back to my folks with the story about how you recruited Judge DuBose, and that's very inspirational and exciting. I guess what I want to look at, though, is, yes, the surface level, the functioning, the procedures, but with the whole, the issue about, we can't, substantive is harder to have a discussion about because it does come down to case law. I mean, when we have equal protection claims and what is discriminatory and what's not, the law is based on very deep philosophical, ideological conclusions. Otherwise, none of us would care who was on the Supreme Court, and it wouldn't be such an issue. So I guess, I don't know if there's even a question in here that you could answer, but thoughts on it. How does the really good, positive, becoming unified energy around DEI, around representation, around sort of the procedural aspects of it, how does that turn into the way we think about doctrine, the way that we acknowledge that so much of the fundamental legal principles of this country, of this Constitution, are built on white supremacy? How do we acknowledge it while we've all taken an oath to support this thing that it comes from? And how does it come through in our doctrine, in our analysis of, is it this version of the facts or that version of the facts that really rings more true? So I don't know if you have thoughts or just wave a magic wand, maybe we could do.
I thought I had tricky questions, so just.
What is obvious to everyone, but became painfully obvious to me when I became a district court judge, was how, I think John or Peter said it, how set the law is at our level, right? Not so much in Rhode Island law, which we don't have as much, but when it comes to federal law, when it comes to equal protection, constitutional issues, or whatnot, the law as we have to apply it is pretty well set. Where the district court, I think, what gets me excited, what gets me up in the day, is that the district court is where the facts meet the law, right? Or the facts meet the Constitution or whatever, and it gets applied to individuals, right? So it's not majority rule Congress, it's not the president having to follow the law passed by, but we figure out how the law is given to us by either the legislature or the First Circuit of the Supreme Court or the Rhode Island Supreme Court, how it applies to a fact pattern that comes our way. I call it to the individual. And that's where the work, in my opinion, the work of the district court is so phenomenal. It's where these concepts actually meet reality. And so So oftentimes, look, do we occasionally, I mean, Judge Smith particularly in a few instances, do we occasionally get to move the law in a direction that we want to go? Yeah, sometimes. Not very often. Do we get to apply the law as it's given to us in situations that meet the moment? Yeah, all the time, every day. I'll give you an example. I wrote an opinion, I can't remember the name of it right now, but it was in an employment discrimination case. I apologize if anybody was here on either side. But the issue had to do with, this whole employment case is this severe or pervasive standard that the Supreme Court made out of whole cloth. They just came up with this rule in hostile work environment cases, but we have to apply it because that's how the system, the rule of law works. And I'm proud to do that, actually. But what is severe or pervasive in the law, right? And so 20 years ago, that's actually a First Circuit case that says somebody scooching a woman's behind in the workplace isn't severe or pervasive. I would think many people these days, in today's world, would say a guy that puts his hands in a sexual manner could be severe for her, and it could be pervasive if it carries on. So I think the development of the law as it meets, the development here in our world that we do day in and day out, and that you do by bringing it to us, is determining how the law fits the particular facts given what's behind it. And I get a kick out of doing that every day. That's my favorite thing to do, is to look at that. And if you really want to move the world along, I think it's really looking at the world as we have it now and how does it fit to the values that are defined by existing law. I don't know if that answers your question or not, Shauna, but that's kind of how I see the world and why I just love the district court. And I love to be in a trial lawyer like you all folks.
I'll jump into some others unless there's anyone else. Okay. Taking on a little bit more of a technological bent, do you have any thoughts about the growing use of artificial intelligence in assisting attorneys with cases, or predictive algorithms, or the use of legal analytics?
Sounds like one of yours there, Judge.
Well, I will tell you that I think the judiciary as an institution is cognizant of AI and its impact on a national level in judicial training. We've begun to build in some programming for district judges about how AI is being used. There are some academics around the country who really focus on this, and we tap into these various academics to do training programs for judges. And we just had the one that we just had here in Rhode Island, the mid-career program. I've been involved with from the outset of it. We had a whole session on AI and how it's working and what's good about it and what's not good about it with demonstrations. So there's an FJC pamphlet on AI attempting to educate judges on the basics of what AI is, how it works. So there's certainly an awareness. There are some courts that have adopted local rules that require attorneys to certify that, to disclose if AI was used in the drafting or the research of the briefs that are submitted, and then to certify that a human, an attorney, has actually reviewed the pleading and is signed on to it. So that's happening in some districts around the country. So it's kind of, as it often does in the judiciary, it's kind of, happening on a kind of a local, organic basis. It's all happening out there, and we're going to get pushed along by the technology companies. Westlaw and Lexis are introducing products if they're not already out. My understanding was Westlaw was going to introduce its product January or February of this year, using AI in Westlaw research, and they have developed their own algorithm that's Chat GPT like, and very user-friendly. So it's going to become a real thing. I think we're bound to see that our, new associates, our law clerks, as they come through law school, they're going to be AI competent, and so it's going to be a big thing for us, and we're going to have to figure out how to navigate it. I had an idea in my chambers. It got vetoed ultimately by my law clerks, but so the thought was we had an interesting case, and I suggested that we write two decisions. We have one what the law clerk would write, and then the other we'd have AI write, and then we'd compare the two and see how they matched up against each other. But I was persuaded that might not go over that well if depending on who found out about it and how they felt about it and so forth. So anyway, I didn't do it. But it's going to be a big thing, and I think it's probably going to be a bigger thing in your world before it becomes a really big thing in our world, but it's inevitable.
Can I just say something about it, because I really don't know much about AI, and I would have voted yes for that experiment. But I look at it from a 30,000-foot look, and I think my husband's a middle school teacher, and he has kids who are using AI to write things now, which is a big problem. And then I think, because of course I always have to play devil's advocate, well, why do kids need to learn to write competently if AI is going to do it for them in the future? It's kind of like, you don't necessarily teach them how to drive a stick shift anymore, because those things don't exist anymore. But by the same token, I also have a friend who I spoke to who's a judge in another circuit, and they had a case where AI was involved, and the lawyer had the brief written. There was a site in the brief that she didn't recognize, and she asked, I guess, or he asked the AI to give them the case, and the program created a case out of whole cloth. And so this person filed a brief thinking this case existed, and it didn't exist. So I don't think it's there yet, but I think it is getting to the point where you don't need to learn to drive a standard. I think that's sad in some ways. Maybe we'll all be obsolete at some point, but I'm not sure. I think that's going to come from the bar more so than the court. We're going to end up reacting to it, I think.
I'll tell you something fun to do. After this presentation, I went home and I thought, what could I ask AI to do? I said, well, the one thing I know about is myself, and there's a lot of stuff out there. So I downloaded ChatGPT, and I said, write a biography of me. It's really fascinating what comes back.
Was it pretty correct?
The first couple of lines were correct, and then it said I practiced law at Higgins, Kavanaugh, and Cooney, and that I had, clerked for Judge Lagur, and it just had all these things that it just made up all these things. It talked about some decisions I wrote that were written by judges in the Superior Court, and it was crazy. So go on, do it for yourself. It's fun to do. ChatGPT, or there's a couple of other programs, and just ask it to do that, and you'll see that it's not quite there yet.
Can I just add quickly? I think that part we're going to solve, just like, remember when calculators first came and people thought it was going to be the downfall of math? I think the AI aspect of the work that you do, that's going to be figured out. What I can't figure out how we're going to deal with this illegal community is authenticity. And I think the issues of authenticity within the federal rules of evidence and AI are going to be some of our, and the world's, some of our biggest problems, and how that's going to be developed. That's one. Two, I was talking to Nicole Benjamin last night, the president of the Raw and Bar Association, and she said that the ABA is currently seriously and deeply looking at the issue and proposing some guidance and models, so we can hopefully get that as a basis for kind of some discussion forward. But don't think about the authenticity issue too closely, because it's scary.
Just a quick comment on the AI. I'm a member of the Wisconsin Bar. That's a long story. I won't tell you why, but I had to take a CLE the other day, and there was the executive of Fastcase He was very interesting. They are, I think, for a lot of us in the room, I suspect, use Fastcase. I don't use Westlaw. I don't use Nexus, primarily because my clients won't pay for it. But I find it to have been primarily a pretty effective tool. But anyway, they're currently on version 7. They are already have version 8.1 in the works. Maybe about 6 or 7 months away, which is going to incorporate AI. And you're going to be able to ask a question and input a question, a legal question, much like you would in Google. And it's going to spit out all of your authorities, and it's going to give you your arguments for, your arguments against. So it'll be interesting to see what exactly that looks like. But, you know, one of the arguments that he made was, you know, they're trying to bring legal research down to its lowest common denominator, meaning why, if I'm a lawyer, the results that I get from my client, why should that depend at the end of the day on my ability to put the right, correct research buzzwords into, you know, the search parameters? And that resonated a little bit with me. I think Judge McConnell is right. At the end of the day, this is going to work itself out eventually. But it's certainly not going to abrogate, in my mind, duties as lawyers. Just like you got to proofread a pleading before you submit it. And I still, to this day, it's my pet peeve. Occasionally I do it. Much to my embarrassment, the other day I submitted a pleading that had a typo on the first page in the case caption. And I immediately called the court clerk, because in New Hampshire, there's no right to amend as of right. You have to file a motion. But she said, I haven't processed it yet. So I said, good, don't. But my point is simply that I don't care how far AI goes. It's not going to abrogate our duties as lawyers to read what we file and read the cases that you cite. Because at the end of the day, it ain't AI's name at the end of the pleading, it's yours.
Lynette, did you?
Comes from, I think, either ignorance or lack of understanding. But to me, Westlaw, every time I take a brief that I wrote or my opponent's brief and I run it through their tools on WestCheck, that, to me, that's AI. It may be AI light, but I think we've been working with AI for years. And most of us, I hope, or, you know, when we it says read this case or recommended cases or yes, use this case, actually go back and read the case. But the other thing, and this is just something that struck me in this, the one corollary of all this craziness that's going on campus, and I'm not getting into that part, is plagiarism. And I believe that plagiarism is a time-honored tradition of lawyers and judges. We all grab stuff from the last thing we wrote, the last thing somebody else wrote. The court grabs the good lines from our advocacy. I'm fine with it. But I mean, I think we need to acknowledge, because my daughter's in academia and she tells me about all this stuff they put through when the students write it or what she's written, and they're all totally fixated on plagiarism. There's got to be some kind of a middle ground on that to lighten up, but that has nothing to do with anything. I just thought I'd throw it out there.
As we approach our end time, I was going to actually allow the panel, if there's anything specific they'd like the rest of the bar to know about or to inform us about.
All right, this isn't, I don't know if this is something I want the rest of the bar to know about, but I want to make sure that the advisory council, and this is tapping into a topic that I think this panel hasn't directly talked about, but was very much the focus of the earlier panel, and that is access to justice and the unrepresented, and how we as a district are appropriately, with due regard to some very complex tensions in pro se cases brought against the state, and getting attorneys involved at the right point in time with the right skill set, and providing for expenses for those attorneys. It's something that I actually worked on a long time ago that I think is really now in your hands. That is, how do we budget for such expenses? Should we be paying more, for example, for a case that needs a medical opinion? Right now, what a pro bono attorney can get reimbursed for bears no relationship to what it costs to purchase a medical opinion. That's something that I think really needs to be a topic. The percentage of what's pending before us that involves unrepresented litigants is significant and rising. I think one of the things for our bar to be thinking about is folding the bar into that percentage of our cases in a much more meaningful way. And that really means looking at how do we as judges make the decision whether to appoint counsel? How do we manage our pro bono panel, which we do have one, but I think it could be managed better. And then how do we deal with allocating funds from our bar fund to pay the expenses of those pro bono attorneys so that a prisoner with a medical malpractice case, for example, is going to have a similar ability to have those issues appropriately addressed as someone who's living in a middle-class community. So it's my speech. Done.
Well done.
Anyone else? Just leaving for open. All right, any last questions while we're hitting the time? All right, well, oh, sorry, Lynette, yeah.
Can the court reach out, for example, to the medical society to see whether they would be willing to create a pro bono panel as well for, preliminary medical decisions or something like that, or opinions? I mean, is that something that...
Yeah.
That's a possibility?
Lynette, can you pass the microphone behind?
Why is the disconnect? Why is there a disconnect between what it costs to get the medical report, for instance, and what you have available for it? And how do you fix that? Because that's the issue. If you try to get people to do pro bono work, you can't include in that a requirement that they go and elicit pro bono services from other people.
Exactly. Yeah. So on the criminal side, there's some better answers because the Criminal Justice Act and the funding for that has ways to push up what an expert can be paid. That said, we also do find ourselves pushing back. Michael Simoncelli actually does all that work, right, George? Figures out how to tell really expensive doctors to sort of figure out a way to do better. But in the civil arena, right now, pro bono expenses, if the attorney was appointed through our pro bono panel, then that attorney can seek reimbursement of expenses from the bar fund. However, the bar fund has to be approved now by the advisory council, and it functions as all such things do with a budget that's set in advance, and there are per case caps, which are, in my humble opinion, utterly unrealistic for what's the actual cost of the expenses in a real case. But there has to be some controls because we're spending the people's money, and it has to be done carefully and thoughtfully. But right now we've got an infrastructure that was created 8 or 9 years ago. Prior to that, we had nothing. So we have an infrastructure that says out of our bar fund, a certain total amount is budgeted each year. We've never come even like to 20% of it, Nora. So we're not spending it. So it's sitting in the budget year over year over year being budgeted. I think the reimbursement amounts are so low that no one's bothering to ask to be reimbursed. And it's a per case cap that doesn't look at the category of the case, doesn't look at the cost of the expert. It's completely unnuanced. It's just, that's what it is. And I think that's a real deterrent to realistically spreading highly competent attorneys over this swath of unrepresented litigants.
What's the mechanism for changing it? Which committee?
You guys.
Does it get assigned to one of these committees?
Well, yes. I mean, I think there's a pro bono subcommittee and access to justice. And then overall, I think that's where the proposal bubbles up, to look at what we've got and then think about how what we've got can be better calibrated to achieve the goals we're trying to achieve. Think about the goals. I think some of the repeat offender defendants in these kinds of cases ought to be at the table. For example, the state is very frequently the defendant in many of these cases. And they ought to be at the table to be thinking about what's fair and appropriate. And ultimately, I think the setting of the budget that comes out of the bar fund, Nora knows exactly what the path is, but there's a path to bring it to approval, and that's the path. But I think the people that we're talking to are where the input ought to come to us from.
And with that, I think Stacy has a new member of a subcommittee that just volunteered. That's you. Yeah. So you've talked to Stacy when you're done. And I think we should all thank our panelists very much for their time and their wise words. And thank you to Nora and Raina in the back for putting on such a great CLE, and all the committee chairs. And thank you all for being here.